Minister, maybe when you first introduced this bill, you might have thought that you had Canadians on side with your approach in removing mandatory minimum sentences. But, Minister, that is definitely no longer the case. We're now in the middle of the Nova Scotia inquiry about the horrific Portapique murders, and my home province of Saskatchewan has just this month experienced a terrible murder spree at James Smith Cree Nation and Weldon, where one of the murderers had been released after 59 criminal convictions, including some very serious crimes. So maybe you should speak to the people who were terrorized this month of these rural Saskatchewan and Indigenous communities about your, quote, real community safety, quote, that you contend is your approach with this bill. Minister, in 2015, Miles Sanderson was convicted of repeatedly stabbing his former father-in-law, Edward Burns, and his former mother-in-law. He received a shockingly low sentence of 2 years less a day. And then this month, at James Smith Cree Nation, Edward Burns was murdered, and his wife was so badly injured that she could not even attend her husband's funeral. Minister, Canadians are no longer on side with your government's soft-on-crime approach that's epitomized in this Bill C-5. Why won't you consider the victims who will be so hurt by this approach and back down on pressing this bill?
Thank you for the question, Senator. With respect, and certainly I send my condolences and my all of my empathy to the victims of both what happened in Saskatchewan, as well as Nova Scotia. But it is simply unfair to associate minimum mandatory penalties and removing minimum mandatory penalties and giving conditional sentence orders with the two situations that you have raised. This was a case in Saskatchewan of a statutory release, a person who had served time, but it wasn't a question of a mandatory minimum penalty, and the same thing with the situation in Nova Scotia. So I think in fairness, those are serious crimes. They need to be dealt with. We'll know after the inquest is over and the parole board study is over in Saskatchewan. We'll have a better sense of what went wrong there. We certainly were all horrified by it, and I share that horror. But the question of minimum mandatories is different. The question of conditional sentence orders is different. If we want to respect victims, minimum mandatory penalties have been one of the most significant contributing factors to the slowing down of the justice system, in which a number of crimes get thrown out on Jordan orders. And you can look at that statistically, and it is true. At certain points, 50% of all the challenges, the charter challenges in the criminal justice system, which really slow things down, gum up the works, are challenges to minimum mandatory penalties. And oftentimes they're successful. Oftentimes they get to the Court of Appeal and the Supreme Court of Canada. And where's the victim in all this, waiting as all this goes through the system? If we want to help victims, we need to have a criminal justice system that works more effectively and that gives us fairer results, because that's fair to victims, and that's certainly better for victims. And that's something we heard from victims. So I think this bill provides a better set of balance and allows us to focus on the real causes of what happened in Nova Scotia, and allows us to focus on the real causes of what happened in Saskatchewan without getting bogged down in the question of minimum mandatory penalties.
Minister, when you compare the issue of mandatory minimum penalties to the issue in the States, and maybe I can get into this more in a second round, but the sentences that we have in Canada are so much lower than the US, it's not even close. Plus, we have statutory release, where if you have good behavior in prison, you get out after a third of your sentence is complete. In almost all cases, you get out after 2/3 of your already probably low sentence is complete. So how can you really compare the Canadian judicial system sentences to those of the US?
Well, that to the extent that I'll grant, for the purposes of discussion, that you have perhaps identified something with respect to sentences, although I'm not going to grant you that completely. There are significant movements in the United States to have statutory review of all sentences because they are so long, because they are realizing that incarceration simply does not work. I have spoken with a number of experts in the United States. They would like to see the kind of parole system that we have here, but if they can't have that, they would like a statutory review system, because incarceration increasingly is not working. And it demonstrated to not work against recidivism or any of the other things that we're worried about in our system. So again, let's talk about minimum mandatory sentences. That's what we're talking about here. Serious crimes will always have serious consequences. We're not talking about that with minimum mandatories. And the assumption that a judge will always give the minimum mandatory penalty or will automatically give the mandatory penalty is frankly simply wrong.
Thank you, Minister.